beyond the halfway mark. So we just have to push today and tomorrow. We are almost at the finish line. So today, ladies and gentlemen, we carry on with the topic we closed with yesterday, whereby we were discussing the methods of securing the release of the accused from custody. And when I say release, it also includes, yeah, no, let's stay for now. Let's focus on release from custody. So the first way we do that, I did say it's through a bail application. And I discussed the purpose of bail being that it is to secure the attendance of the accused to court, and the aim with a bail application is to minimize the impact on the accused freedom at the stage when they have yet not been convicted. Now, the general principle is that the accused is entitled to be released on bail at any stage before a conviction, based on the presumption of innocent until proven guilty. The court should be satisfied that the interest of justice permit the release of the accused on bail. And I did talk to you that you must watch out for that expression, because it works sometimes in favor of the accused and it also works against the accused, depending on how the courts would view the interest of justice. Bail application, I emphasized that it is always urgent in nature. So it implies that it must be dealt with at the earliest available opportunity. I discussed that case of Stuttenheim versus Mashia, and I did show to you, ladies and gentlemen, how the Supreme Court of Appeal applied their minds to the agency of a bail application. And further, bail is entirely non-penal in character, and therefore a refusal of bail should not serve as a punishment, nor may a court fix an excessive amount or erroneous conditions of bail in a bid to harass the accused. See the State versus Acheson, the case citation is there, where there was an acting judge, Mohammed, who said that the accused person cannot be held in detention pending the trial as a form of an anticipatory punishment. And the presumption of the law is that the accused is innocent until proven guilty. So with your more serious offenses, you would often notice that the courts, they tend to refuse bail applications, and one of the reasons they would give, amongst others, would be the fact that the charge the accused is facing is a very serious offense, and there is a likelihood that if the court would convict on that offense, the punishment, or rather the sentence that the court is expected to impose, it's going to be a very hefty punishment on the accused. So they would equate the seriousness of the offense with their decision to decide whether to grant bail or not. So that kind of behavior should be totally discouraged. because the allegations being made out of on the accused that they have committed an offense which is said to be serious should not be the main factor that the court would be basing their decision on in determining whether to grant bail or not. There are lots of cases, ladies and gentlemen, where the allegations, or rather the offense is serious, like it's your robbery, it's your murder, it's your rape. The minute we hear those words, we know those are serious offenses. But now, when you go into the facts of the case, that is where you will find that there is a lot that is lacking in the state case. And therefore, you can see that the state will have a big challenge to prove that charge that they are leveling against the accused. So often the practice is that, especially in the lower courts, the district courts especially, when accused persons appear for first appearance, because that court, for those that are dedicated even, or even mixed, like being a hybrid court, where you find a court that deals with both first appearances and trials. And because of the amount of cases that go through that court, they don't really take time to dwell much on the facts of the case. Once the accused appears before the court, the presiding officer will ask, prosecutor, what is the charge? And they will say the accused appears before the court on a charge of robbery, in that it is alleged that the accused robbed a cell phone from the complainant. Maybe there was also an allegation of weapons being used during the commission of the offense. So that is how brief they will be in terms of the facts of the case. And then the next question you will hear from the presiding officer is, what is your attitude on bail? Now it's the presiding officer is asking the prosecutor, are they opposing bail? Are they refusing that? Are they not opposed to bail being granted? So then on those very minimal facts that have been put before the court, the response would be bail is going to be opposed, maybe because the offense that the accused appear before the court falls under one of the schedules where bail is supposed to be opposed. Then the accused would have to actually bring a formal bail application before the court can consider to grant bail. So what happens in those cases? The case will then now be postponed to a future date. Remember, I said this is a busy court. There's a lot of cases going through that court. So they would then say, because this was just for a first appearance, then the state is going to request, if the accused has already indicated that they want to apply for bail, then they would say the state would request that the matter be postponed to a date of at least 7 days from that day to come in now with the issue of bail. So sometimes they do actually deal with the bail on that very first appearance, but I can tell you in these district courts, it's very little information that is put before the court. So, and also you coming on board as a defense lawyer, you will have a challenge as well, because you are not having access to that docket. So you will have to argue your case based on, instructions that you would have got. If the accused has some knowledge about the matter, then you can shed a bit of light to show the court that the state might not be able to secure a conviction. So because of that fact that you don't have a right to demand that you be given the contents of the docket at that stage, you just have to be smart about it, and you can be friendly maybe with the prosecutor, not of course to the prejudice of your client, and maybe politely ask them to give more information on what kind of evidence do they have, if they are able to tell you. But yeah, you are solely at their mercy at that point. If they are not even friendly, you'll have a very, very difficult task to show that you know the case will likely not even be proven in the court. So it's all up to them as to what they can disclose at that stage, and they can choose to give you very little information, and they will tell you it's because at that stage they are still conducting investigations, so they can't share too much information about the case, and it is going to be allowed that you won't get that much information. So yeah, I just had to say that it becomes really, really challenging to get that bail, especially when the state is not open with information. Like, they are really playing their cards very close to their chest, so you're not gonna be able to get anything out of them, especially when they are confident that they are going to succeed with a conviction. So the courts should always avoid improper pressure when considering a bail application. For example, when there's a threat that go on a strike if bail is refused, that should not be a factor that will force the court to grant bail, or that people opposed to the bail being granted to the accused will resort to illegal activities if bail is granted. So here we are talking about those high profile cases that you would normally find the media giving coverage of those cases in court, and you find the members of the community and some organizations, and mostly you will notice that most of those people who are coming to express that they don't want bail granted, it's normally our elderly mothers who will be coming there to chant and shout slogans like "No bail for rapists," and they'll come with placards at times. So the courts are urged not to be influenced by those kind of uh, chanting that they sometimes they can actually hear, because if the court is not that big, the people who are outside chanting, the presiding officer, sometimes they can hear that there's slogans that are being shouted outside the court buildings. So I don't know how they are expected to ignore what the ears can hear and what the eyes can see, but they are expected to not bow down to that kind of pressure. In this matter of Van Veenendaal versus Minister of Justice, the court held that such a threat creates a basic and untenable challenge to the legitimacy and the credibility of our legal system. And our courts if they succumb to this, it's not fair for the judicial officers to succumb to that kind of pressure. The rules of evidence for purposes of bail are relaxed. So here we mean that in a bail application, information can be introduced, which is actually a hearsay evidence. And as we know, the rules of evidence is that hearsay evidence is inadmissible. But a clear example of this is with the investigating officers evidence in a bail application. Remember, the investigating officer was not at the scene of the crime. They are not an eyewitness. They only collected statements from the state witnesses, and then they are expected to prepare either a statement concerning this bail application, or they actually come to testify in court about the allegations against the accused. So all that they will be telling the court is hearsay because they were not there. But because this is a bail application, that kind of evidence is going to be allowed. Two types of bails that we start by dealing with. It's your police bail. Shortly after the arrest, Section 49 says that once the accused has been informed at the police station that they are under lawful arrest, a police official of a rank of a sergeant or higher is able to fix bail for a first appearance of the accused if the focus is on very less serious of like your assault without any injuries, maybe no weapons in any way were used in the commission of this offense, malicious injuries to property without the value not being too high, or someone maybe who drives a vehicle without a license. So it's your minor offenses that would not carry serious consequences that a person would likely to be convicted and sentenced to imprisonment. So this police official makes their own mind up that I'm comfortable to give bail at the police station before this accused actually appears in court. And if they do so, the whole process of paying the bail will be followed. A receipt will be issued when they pay, and then from the police station, the accused is released. That is a police bail. For some of these offenses, ladies and gentlemen, do not be surprised that it may be one of those that fall under this schedule, but the officer may tell you that yes, it's one of those offenses where I'm actually authorized to can consider granting bail, but I'm looking at the sensitivity of the matter and for the fear that I could be blamed for having granted bail and something going wrong after I had granted the bail, I'm not going to grant you the bail. So you can't force that police officer. If they tell you that, then there's an hour after hours a prosecutor on duty for these after hours bail. If you don't get the bail from the police, then you can go and try with the prosecutor. Their authorities extend beyond those of the police official at the police station level. Kwanele?
I hope you can hear me.
Yes, we can.
Yeah, I just have a silly question here around that offense of driving without a license.
Mm.
Is which is the offense? Driving without being licensed to drive, or driving without carrying your license, even if you are licensed to drive? Because I've seen quite a couple of things where people get into a tussle with traffic cops or the police because they were not carrying their license in their person at the time when they get stopped. But the person can like say, okay, let's drive home and then I can pick it up, but then they get into trouble. So what really is the offense there? And I did qualify my questions as silly, so please forgive me.
The offense is that every driver is supposed to be on the road with their driver's license. But if you can have a valid reason to say, I actually do have a driver's license, but because I was, changing my clothes and I made a mistake, I left it in the pants that I changed before I left home. It's human error. It can be pardoned. But the law is that everyone must drive a vehicle with a license on hand. That's why when the police stop you, they want to see the license disc of the car and they want to see the driver's license of the driver. Okay, just for your clarity there. So that's why most of the time then they would issue you with a ticket and at times if you tell them at the scene that no, I actually do have a license but I forgot it at home, and then they will say, okay, we can't just let you go. Here's a ticket that we are bound by law to issue to you because you were found driving a vehicle without a license. But if you can go and make representations to the prosecutor in court and bring that driver's license along and show them that it's a valid license, then they may consider withdrawing the matter from there and then you are pardoned. But it's an offense to drive a vehicle without a license. Okay.
All right, ma'am. I just think really it's ridiculous though.
It's not ridiculous, Papa. The bad things happen on the roads, so there has to be laws and regulations to regulate this. And we know that a lot of people are still driving without a driver's license. So now, when you went through the trouble of going to learn K53, you paid money to take driving lessons, and then somebody just comes out of nowhere, boom, they hit your car, and when you ask, "Where's your license?" they don't have it. Is that ridiculous? No, people must obey the law. The laws are there to keep, order. Yeah. So let's not digress. So
Sorry,
then,
ma'am. I'm sorry. I'm just saying that being in possession, I think, okay, let's not digress. I'm sorry. It's fine. Let's
okay.
continue.
Yeah. So you want to argue with the law, then read the traffic laws and then maybe make some cases that are going to get the law to be changed. But as it stands, every driver must have a license with them. So prosecutors bail, Section 59A, capital A, it authorizes now a prosecutor to release a person on bail before the first court appearance. If the accused is in custody for your Schedule 7 offense, such are slightly more serious than the ones I've just discussed now, and in this case, a police official will not be able to grant the bail, then we are looking at if it's assault, there's grievous bodily harm, culpable homicide, common robbery, theft. The value also will be very minimal. Fraud also, so possession of drugs. But even with this section, ladies and gentlemen, you still get prosecutors at the police station after hours bail being refused, because they would give you their reasons that, look, yes, for assault GBH, I am, empowered to grant bail, but on this matter, I'm looking at, the injuries inflicted on this victim. They are, very serious, or maybe the the choice of weapon used to inflict the injuries also. It's not like it was just, a punching with fists. This person actually used a weapon that could have actually killed, the complainant. So if they feel that, or maybe, if they feel that, the weapon used was also aggravating in itself, even if the offense is not attempted murder, but it's borderline to being almost attempted murder, then they would tell you that I don't want to be blamed for that, or especially with your GBV offenses, where there's gender-based violence between, maybe a couple, or people who are in a relationship, they are likely not to grant you that bail. And where maybe there's a past history as well of a report that this is actually not the first time that this is happening, that the complainant is being assaulted, they can also say that, no, we are not going to grant you bail. Go to court and apply for bail there. Yes, Richard.
I hope you're well.
I'm just a bit drained, but yeah, I'm fine, Richard.
I must make a comment. Your lectures very well this week. One of the best so far. But I need to make a comment to my learned friends out there. And what I picked up, and this is a general comment I want to make, is that I picked up since Monday till today that some of the learned colleagues has an issue with the police in the way they conduct themselves. Now, you get good policemen and you get bad policemen, and then you get very good policemen.
Yeah.
And we shouldn't shadow everybody under one umbrella.
Yes.
And the reason why I'm saying this, I've been listening to the comments, and it depends from each case has its own merits. And
Yes.
you've touched on a point of section 59 with regards to bail before the first appearance in the lower court. And then we're touching on section 59 where the capital A, where the DPP can bail. And I think what we've learned since the 5th of June, when we started these classes, is to build relationship with the prosecutor, with the police officer. And I think once everybody is in practice, or if you've been in law enforcement, or you at the NPA, or you're doing your articles, build relationships. And it's all about the attitude. If you walk into a police station and your attitude is right towards the police and not battering the police and battering the prosecution, your client is going to get bail or go out on warning. And I picked up this week, and it might sound like I'm repeating myself, is that especially when we touched on the Comedy case and the other matters prior to the Comedy case, I just get the sense that there's some anger towards the law enforcement agencies. And we should change that attitude, because the Constitution is there. Use the Constitution, use everything in your power, but it's all about the approach and the attitude. That's all a comment I want to make. Thanks, Elsie.
Thank you so much, Richard, for that comment. And really, it's good what you have said. And I was actually thinking, it's just that I think I had a long day today. I was thinking when I was at work today, I was thinking that, you know, normally when I start these classes for criminal court practice, because it's not the only course that I do, you know, I like to throw a disclaimer. And the disclaimer, it normally goes like this. But ladies and gentlemen, of course, I want you to like criminal court practice. I want you to develop an interest in it and see the importance of all of us knowing, you know, how to handle ourselves should we one day find ourselves in a criminal court, you know. But the thing that I like to say is I do my best to give as much or rather share as much of my practical knowledge and advices and tips based on what I know, but I think also it may also show its ugly head too many times, that I do sound to be leaning more towards the defense because I am a defense lawyer. That is what I know how to do. For all my lawyering life, it's what I've been doing. But I do try to throw in here and there, other aspects of how to consider the position of the other stakeholders that are involved in criminal cases, like your police, like the presiding officers. But also I'm mindful of the fact that, yes, I'm here to train defense lawyers. And it is good for you, Richard, to just throw it in there that people shouldn't have that, attitude of being anti-police and, considering the state as the enemy, for lack of a better word, because when you do get there, you are at their mercy. That's why I do throw in words like that, because they have information that is going to be useful and helpful, not only to make your job easy in order for you to assist your client. So it is indeed true, Richard, that you can't come there and throw your weight on people and be like, yeah, what do you know? Because you are a big shot lawyer, it doesn't work. Even when we are training our CAs, we tell them that, look, in court, you may actually get help from the last person that you would expect, maybe an interpreter. As much as I spoke to you guys about the wrong interpretation, most of the interpreters that are in court, they are like regulars in a specific court. So they know the attitude of the presiding officer towards certain issues, whether if it's this kind of offense, you can likely know that you're going to have a tough time maybe to get bail. And they can even give you pointers that, if you want to get bail here, you know what, show this or address them on this issue, because they've been working with them for a long period of time, so they've come to learn their habits and so yes, you may come to court. Also, I say to the CAs, sometimes you may feel that when you come to court, because these people are elder in age than you, because they can see you are fresh from school, you are still a youngster, you are a newbie in the game. They may also, you may feel, let me rather say, you may feel that maybe somehow when they are trying to help you, to give you those pointers, like they are undermining you, that they are expecting you not to know what you are doing. But you'll be surprised that actually their intentions are actually good, because maybe they think that because, you know, because maybe the stature, some people are so tiny, like, but in age, they're actually, you know, much older than what the interpreter or the stenographer is looking at them, and they probably thinking, oh, this young girl, when they're looking at you, they're looking at you like that, you know, they're not looking in a way of demeaning you. So they somehow feel a sense of like she may need help. Then they may try to help you by giving you pointers, and some may feel that they are overstepping. So you need to understand also where they're coming from. Draw the line if you feel that they are really overstepping, by letting them know that no, please don't undermine me. This is my case. I've come prepared. I do appreciate you trying to show me whatever, but yeah, I'll take it from here. So, but thank you for, you know, whatever advice. So just know your stuff, stamp your authority where you need to, but don't trample on anyone. That's the sermon we normally give, because you may actually be, for instance, an example of a 174. You are unsure whether you should ask for this 174 or not, because it's your first time. Maybe you haven't really done a trial. Guess what? Those interpreters, they will sometimes even whisper 174, 174, you know, without showing the code, so that they are trying to help you, that don't even go any further. Yeah, they know if the evidence presented before that court is normally like the way it looks. Of course, you still have to make up your own mind whether you are going to stand up and ask for that discharge, because you will have seen the quality of the evidence that is there, you know. But I personally, I have benefited from some of those court officials, you know. And yes, indeed, good attitude will always take you far. Like, even if it's just a bail application, like you see, we say with bail applications, you don't have a right to be given access to the docket. But with good attitude, I get the bail docket most of the time. They don't make me copies, but they can, you know, allow you to maybe turn a blind eye and you can read through quickly. It's not against ethics. They give you, I mean, it's their permission, but the thing is, you can't demand that you want to be given access at that stage, or you demand to read the docket. But because they know the rules, that at that stage they're not supposed to give you the docket, but they can use their, you know, discretion if your attitude is good, to allow you to read the docket. Then when you are preparing your bail affidavit, you have the whole information of the case, and you will know how to better deal with the allegations in that docket. So attitude is definitely everything.
So, sorry, Elsie, and I'm just interjecting, but I fully agree with you. And I just want to say this to all the learned colleagues. I've been through this. I've been 37 years in the law enforcement prosecuting agencies. Speak to your senior prosecutor, especially when it comes to December time, November, December time. Go have that braai with the prosecutors and the magistrate. It's one big jaw, and you build up contacts there. Take that as a tip tonight, guys. Thanks.
Yes. Some even I call it resident private attorneys. You know, it's funny because, you know, no attorney is supposed to be attached to any court. But yeah, we know the ones who are regulars in specific court. They even give contributions, like when they are raising monies to do those Christmas parties and whatever, because in the spirit of working together. Samewerking. That's the spirit. Ubuntu and samewerking, because we are all colleagues at the end of the day, you know. So yeah, thank you so much, Richard, for that. Yeah, Tsholofelo, I think you're next. Oh, is it Sipho? Sipho first. Sipho Ntambo. Okay, maybe we've said all that you wanted to say. Tsholofelo?
Yes, good evening, Elsie.
Hi.
Yes, to add on what is it Mr. Richard has said, you experience a lot in practice, because I know most of my colleagues here are for defense and, not actually on state side. Most of them, when they come to court, especially for bail, their attitudes, I don't know if it's a pompous thing or because you are big shots lawyers and you're being paid big money, you don't even interact with the prosecutor to know what charges have been inferred. Some of them are even surprised when the charge sheet is handed over to what the charge sheet says, because what you did not talk to the prosecutor. Because at the police, remember, they're going to just formulate a charge based on what they think is happening. But at the end of the day, the prosecutor is the dominant litis, is the one who's going to actually read the docket and say, no, the elements of this and this are present. Now I'm charging, let me say, robbery aggravating. But you are there thinking, your client told you, or you're thinking, oh, it's just a silly Schedule 1 offense. But because you did not communicate with who the dominant litis, the prosecutor, you are now caught by surprise. Bail won't even be entertained on that day, because what? Maybe the matter is now a formal bail application. So guys, it's very important to have a relationship with other court officials, even the interpreter, as Elsie said, because these people, they know more than everyone, because they've been there more than, they're old, like older than the furniture, some of them. I remember I'm telling you, when I started, interpreters would help me in certain cases. I'm like, what do I do? It's like, say this, say this. Those people know. So get in there, be friendly. Let me tell you, it's gonna go a long way. Don't come there with big shot attitude. I've been paid big money. I'm telling you, that's not gonna get you anywhere. So attitude is so important, guys. Talk to us. Let's talk. We are all
Talk to us. How? I thought you are joining the ranks of the defense. How? Wow.
No, I'm just saying, talk to the prosecutors, go to the offices in the morning and talk to them. What are the charges looking like? Can we entertain bail? Don't just get there and you understand, just attitude, it goes a long way. You can even, I don't want to it's important. That's all.
Yeah, no, true, very true. All what
Yeah.
you said. They would even do you favors that you didn't even ask for. I'm talking about, because remember, this prosecutor knows the whole entire case. They also said since yesterday with that docket, and they know the loopholes. So they can even surprise you and go on their own to their senior and tell their senior that, you know what, here are the loopholes here. We're not going to be able to prove our case here. And they will come to you and just tell you, when you came there believing that you are coming to fight, and they'll be like, no, the charges are going to be withdrawn. So they done your reps for you, you see. So yeah, true. Veronica?
Hi, Elsie. I hope you can hear me.
Yes, we can.
Yeah, thank you. I just want to say thank you to you and Richard for the guidance and so on. I think for me, I don't think it's a matter of having a bad attitude against the police. I think if you grow up in an area where you've seen things and where you see that things are not done the right way, people are, should be arrested, and the next thing they're out on bail because they've bribed this one and that one. That's where it sometimes comes from. But we know, we are learning from you to say that when you are in the system, you do when you are in Rome, you do what the Romans do. But it doesn't take away the fact that you grow up in a township, you see all these bad things happening, and you can't help but think, what is going on with the cops and so on. So it's if you've been in that situation, that's why we have that. It's not an attitude towards, it's just, it happens. The things that happened really, like, it makes you wonder. Yeah.
No, there's corruption. Like as Richard said, there's bad cops, there's good cops, and there's very good cops. So we know there's bad apples in every state organ. So we are not excluding the fact that yes, there are those who are bad, but we are just trying to make your experience not to be unnecessarily horrible. If there's something you can do to help the situation, to just get what you want and leave, because at the end of the day, you are paid to do a job, and it may be your first time, so you don't want to meet up with people who are gonna give you a tough time, because maybe you not to say you must be like a beggar, and I don't know how to use wrong words here, but yeah, but the truth is, if you are cordial, polite, and when necessary, friendly, then you'll get away with more than if you come there and you be like, don't waste my time, whatever, bad attitude. That's just the point. Yeah, I think we've milked this cow. The milk is finished. So the point is well noted that we do have to try and adjust to the situation as you see it, to make it back to make it work best for you. You will determine how things are, and the earlier you make things friendly, then you are likely to have easy going. But if you come with, yeah, I think you understand. So the next topic here is the general powers or the duties of the court at these bail hearings. A court can postpone the bail proceedings if necessary. Section 60 is all about bails. So all these subsections are from there. The court can request information needed for a decision in an informal manner if the state and the accused do not dispute this. The court can require that the prosecutor or the accused lead evidence in matters which are in dispute. To require also that the prosecutor to place his reasons on record why he does not oppose bail on a charge that falls under a Schedule 5 or a Schedule 6 offense, because those type of offenses are very serious, and it is expected that the state will be opposing bail. So if they say they don't oppose, then remember with Schedule 5 and Schedule 6, you have to do a formal bail application, because automatically the state is opposing bail. But if they say they don't, then the court must be addressed. Why are you not opposing? Because they are expected to oppose that bail. In order that the further evidence or information be placed before the court, I hope you know the distinction. Sorry, I'm just now thinking about this. This Schedule 5 and 6. That you need to note that there's a difference in terms of what you have to prove when you are dealing with, because that is often a question that they can ask in the exams. What's the difference between a Schedule 5 and a Schedule 6 offense? So with a Schedule 5 offense, you just have to show that the interest of justice allow that this accused be released on bail. With Schedule 6, there must be exceptional circumstances which exist to warrant the release on bail. So if it's a Schedule 6, to convince the court to grant bail, you must show that there is substantive and compelling reasons. So with a Schedule 6 offense, it's more difficult and more challenging to convince the court to grant bail, because they want more of what is like extra reasons why they should grant bail. I hope you understand that distinction. Just check also on the manual. I think it may be explained also there. And check also that section. It will help you, section 60, to just be able to clearly know. And also with these substantive and compelling reasons in terms of what you need to show for a Schedule 6 offense, there is no specific definition of what is a substantive and a compelling reason. It is something that the court can be addressed on, and you say this is sufficient to qualify as a substantive and a compelling reason. So case law is very helpful when you want to be able to can diversify which are these factors that you have to say in a Schedule 6 offense. Because there, if you don't show those reasons, you are likely not to get bail. So things like, for instance, there's case law to the effect that someone who appears before the court as a first offender, some courts would consider that as a substantive and compelling. The fact that the state case is not strong, on face value. Remember, it still has to be proven, but on face value, it doesn't look like the state case is going to be strong, meaning that the state might not be able to secure a conviction. That is a factor that can be considered as a substantive and a compelling reason. Yeah, so some lawyers have gone very far and beyond, trying to use medical reasons as well to show those substantive and compelling factors. Like if they say maybe the accused is not going to be able to survive if they are sentenced, if they are remanded to custody and bail is refused in the prison, they would state the medical, circumstances of the accused, to say that maybe correctional services does not have the facilities, or the living conditions will actually render the accused health to be, in danger, because they would, deteriorate in their health because of whatever medical condition that they have. So yeah, you of course, each case will be based on its own facts, and you will then have to look for those special things about your case or about your accused that you would be now impressing upon the court to consider as substantive and compelling reasons. So the court should first, now when the court has been presented with all the evidence, it needs to consider first whether it is comfortable to grant bail or not. If it is amicable to grant bail, then the court needs to check on the amount that it wants to fix for bail. It's a two-legged test. Are you okay to grant bail? And now, how much is the amount that you are fixing for bail? So when you check the suitable amount of money, this calls for the court to now go into the pockets of the accused to determine affordability, whether the amount that the state is suggesting that it should be fixed as a bail amount, is that something that is within the reach of the accused? Because remember, I said, if the court would be amicable to granting bail, and then an amount that is fixed is so excessively high, therefore it means the accused will not in any way be able to afford paying that money, then it is tantamount to a refusal of bail. So whether to in determining whether the interest of justice favor the release of the accused on bail, the court will have regard to the interest of justice as against the rights of the accused, and also the court will check the prejudice that the accused is likely to suffer if this bail is not granted and they are not released. So now, ladies and gentlemen, I want to go into a number of factors that the court is expected to consider when it is dealing with a bail application. The factors are in terms of section 60, subsection A to E. So we are going to try and go a little bit in when we discuss these factors. First factor is that the court should consider whether the interest of justice permit the release or of the accused on bail or not. When the court wants to consider whether it's in the interest of justice to permit the release or not, the court will check this. Remember, I said there is no specific definition given to what is this interest of justice, but some of these factors, they will influence the court to determine whether it's in the interest of justice or it's not in the interest of justice. Where a period spent in custody by the accused, it will be checked whether it's already, sometimes, you get these cases that even if a court were to convict, we are not prejudging the case, but we are looking at the fact that even if it were to ever happen that the same court that is faced with this bail application convicts the accused, the kind of sentence that they would give, it's not going to even be custodial sentence. Or if it is custodial sentence, then the court is likely to give maybe 6 months or 3 months in imprisonment. But if this accused that is standing before the court is applying for bail, they have already spent 8 months, in custody. In a way, we can say they have already served what would have been a sentence they would have been given. So the period that this person has spent in custody, it weighs very heavily on the mind of the court. Also being mindful of the fact that every accused who stands before the court at this bail application is supposed to be considered, is presumed innocent until the state, through its evidence, can prove that they are actually guilty. So where the court is disturbed that this person is already spending too much time in custody, it now hampers on the interest of justice. Is it fair for this person to continue lounging in custody? Or now are we now be even going beyond what would have been the punishment they would have been given for that offense? The probable detention, period of detention until the disposal of the case. So in the courts, the district courts, they have time frames. Regional courts have time frames. High court, they have time frames. When a case is first placed on the roll, in the district court, they expect that that case, if in the ordinary course of events, it should be finalized within 6 months. In the regional court, it's 9 months, and in the high court, I think it's 12 months. So if the case has already been on the court roll beyond those targets of the time frame that they set for the turnaround time to finalize the case, the courts are expected to report what are the reasons they are not able to finalize those cases. So if this is a presiding officer who is dealing with an accused who's been in custody for a case that should have been finalized in 6 months, but already they are now already 8 months in custody. So now this is now looking like it's already a sentence that will also weigh on the court. The reason for the delay, for the delays in the running of the case, the court would check whether those delays are caused as a result of the fault on the part of the accused, or there is no fault on the part of the accused. Therefore, the courts would look at that. The financial loss that the accused is likely to suffer, on account of this detention, because some people run businesses, they are employed before they are arrested, and of course if they are now going to be remanded into custody, the employer is not going to wait. They are going to lose their job, the business will close down. So those are matters that will now weigh heavily to show that it should be in the interest of justice that the court, of course, taking into account all the other factors of the case itself, also not just one side only, but look also on the prejudice that the accused will suffer. Any impediment to the defense which with this defense with this detention. So please check the State versus Atchison also for some other factors that would influence the court to determine whether the interest of justice are now warranting or permitting the release on bail or not. Nontobeko.
Hello?
Yes, we are listening.
Oh, sorry. Thank you. I wanted to understand in securing the release of the accused, some of the factors that would need to be taken into consideration about the interest of justice. Would a community sort of opinion not matter? Because I'm assuming that at times you'll find, especially in violent crimes and as well as GBV issues, you will then find a community that is that reacts to such matters, and therefore they can be able to draft letters to the prosecutor in support of the accused remaining in prison, or even writing letters to get like a super sentence and whatnot. What is the procedure? I think I just need to understand fully the procedure that a community or a person interested in the matter or an organization, they would need to follow in order for their voice to sort of be heard by the court.
Nontabeko, your line is not very clear, but I will do my best to try and answer. I hope I've captured all that you have said. When the court is dealing with a bail application, remember this is an open court. So the members of the public are, welcome to come to court and listen to any case that they are interested in. I mean, I know of people who used to make it their daily, activity because they were unemployed. They used to wake up every morning and they will just go to court and listen to the different cases. It was, I don't know, for growing purposes, maybe having an interest in the law, or maybe out of boredom. But like a court is open to the public. So if there's a bail that they have a interest in, as you know, the public comes to court, they can sit in the court, and of course in court they are not allowed to make those chants and raise any objections or say things against the granting of bail, but they can make themselves visible, as I have seen that those mothers who come to court, they will come maybe bearing the names of their organization on the t-shirts, or they will wear some green and black uniform, which we know is aligned to a certain women organization. So that would tell you, I mean, the court is a human being. The presiding officer is a human being. And they are also watching TV. They know things that we know. So the idea is that they shouldn't interfere with the running of the court, but they are allowed to come and express their opinion. And even the prosecutor, when they address the court, they will tell the court that they are members of the community present in the courtroom and outside the court who have come to court with the intention of raising their opposition to the granting of bail, because that is how the community feels about the offense that has been allegedly committed. So that is allowed to be done. But the court still has to listen to all the evidence that will be presented before it in that bail application and make up its own mind, not being unduly influenced by the fact that there's a group of people who may stone the court building if they grant the bail to that person. They have to be unbiased and fair in their decision. That is how it happens. I hope I've answered you. Tsolofelo?
Am I audible?
Yes.
Good evening. Elsie, this afternoon as I was driving back home, I heard on radio that Jub Jub, the celebrity guy, he handed himself over this morning to the police. And what was interesting for me, because I've never worked for a firm that does criminal law, is that he got bail today, and what they did is they took his passport, so that he does not flee. So I wanted you to take me through on, so how does he hand himself over today and still gets his bail on the same day? It was very interesting for me to say, how does that process go about?
Super! You can't help me, useless.
Oh, shame. Is okay, Tsolofelo. I don't want to talk about that case because it happened where I was working today. So I have some information that I don't think it will be proper for me to say any. I don't want to talk about it. In fact, I really was hoping no one will even bring it up. So that's my
Okay,
you make up your own mind on that one. Yeah.
Just 2 times.
Okay, it's understandable.
So yeah, so those are the factors. Public or individual safety. Court takes into account the following: the degree of violence implicit to the charge. So if there's an allegation that there was violence involved in this crime, was that excessive violence? Was weapons used? What kind of weapons? Was it firearms? Was it knives? Or was it pangas? Or it was, just blow by blow, physical, a fist fights that took place in that incident, or just some pushing and shoving. You would now be addressing the fact that if this court grants the accused bail, the court doesn't have to worry about any person, out there that they are going to be in danger of the accused. Or you could even say, even the court can be, assured that the accused is not in any danger from the members of the public should he be granted bail, right? Because the danger can come from within or from outside of the court. A threat of violence that the accused may have made to any person is normally a report that would be given by the police, that the state witnesses are saying they're being threatened not to cooperate and come to testify. If there's no such, then you will then say that, there's no such threats. And to address the issue of the threats, you would maybe say the accused doesn't even know who the state witnesses are. Therefore, there's no likelihood that they will be making any threats to any witnesses. Any resentment the accused is alleged to harbor towards any person. So this one, remember, if the complainant has made a case against the accused, it can be taken that the accused is not happy that he's become arrested after, this complainant has made these allegations to the police that have landed them in jail. But if the accused says, look, I don't have anything to hide, I know that I'm innocent, and even, the allegations been made against me, I consider them to be false or wrong. But despite the fact that I'm here, I choose not to resent anyone who has made me to be here before court. So the court can consider that I'm not going to be in any way a danger to the person who has opened the case against me. The accused's disposition towards violence, as evidenced by the past conduct. It's the police now who will come with those profiles. The profiles also shows in the police profiles, they show also cases where the accused was accused, but maybe the cases were withdrawn by the complainants because maybe they forgave each other. It's not like SAP 69, which is the record of the previous convictions. This is a profile. It's a profile of all the incidents of reports made against the accused, and the police, they will keep that in their file to show that there's been a report of maybe assault GBH that was made in the past against the accused, but the complainant in that matter had later decided to withdraw the charges because maybe they mediated the matter as a family. Now the accused is before this court appearing on an attempted murder charge. So this is showing a propensity on the part of the accused to commit violent crimes. So that would be how the state would address that. So if they bring that information before the court, then you can't just throw your shoulders down and you feel defeated that, oh my gosh, I'm trying to get bail for attempted murder, and here is all, and the profiles, they can be long, hey? They can be really long. And in different provinces in the country, they will tell you in KZN, there was a case like this, in Limpopo, there was another case, So now it taints the image of the accused before the court as someone who is a regular customer with the courts, So you have to take instructions if you were not aware of those incidents, and come and address the court to say, even if those reports were made to the police, they were never proven that the accused was guilty of those offenses, because at the end of the day, there is no previous convictions against the accused as he stands before the court. And if the court would allow you, you can even say it was because maybe those, I don't know, maybe your instructions are that those complainant, they were actually withdrawing the cases because they had a part to play in the fight that happened between them and the accused, and it's not like they were entirely innocent, or maybe they had realized that the accused was the wrong person they had pointed for having committed. So you'll have to address the court, because if you don't address those reports of past conduct, it's in the mind of the court. And the court can say, this court is not comfortable to consider releasing the accused based on the past history that has been placed before the court, and remains undisputed that the accused has, displayed violent behaviors in the past that have, led to actual cases being made by complainants who, even if they had at some stage decided to withdraw the charges, but the fact remains that there's seems to be some, violent elements that the accused is prone to show in his conduct. So you have to really challenge that. The disposition of the accused to commit Schedule 1 offenses as evidenced by past conduct. So if it's someone who, I think I've just covered that, to say that if the accused was charged with a particular offense and now it comes again, has that other offense, was it ever, has it led to a conviction? And then you'll deal with it like that, to say it was just a mere allegation which was never proven, and prevalence of a particular type of offense. So sometimes if it's assault, like with violent crimes, that's what we are dealing with here, to show the propensity to be displaying violent conduct. If most of those past incidents, they involved violence, and that it was a lot of them, like I tell you, they can be many, you have to explain why this client of yours, many times in his life or her life, they have found themselves, against the law with charges of having committed some type of a violent crime. Do they maybe had a problem, maybe that in their youth, maybe they were having some trauma in the past that led to them displaying those violent tendencies? And was it ever addressed, maybe through therapy, through your client attending life, skills programs to address anger management? And so you are trying by all means to show that in the past, this was a young man or a young girl who was, prone to act out, their feelings without much consideration. But at this point, since those incidents happened, it's like 10 years ago, this is now a grown-up who's, matured, in not only in age, but also in their behavior. They have changed, they have turned a new leaf, they are living, a completely different life. So yeah, what was influencing them in that time is no longer a factor now that the court should worry about. So any evidence that the accused has previously committed a Schedule 1 offense while out on bail is also a consideration that you will have to address with the court, to say, yes, while they are out on bail, another charge has come up again. And now how can this court be comfortable that this person is not a danger to the public? Why can't they stay out of trouble? You'll have to address that. Factors considered by the court on whether the accused will evade trial or not. You have to show the court that the accused has emotional, family or community occupational ties to the place of the trial. So if the court is concerned that the accused will run away and they won't come back to attend their trial, address their living conditions, how long they are there at the place where they stay. Maybe if it's a foreign national, you can even tell the court how often do they even leave the country to visit their country of origin, because there are people who are actually legally in the country, but because it's not cheap to travel, because they have to buy plane tickets and stuff, they actually travel home maybe once in 2 years. Do they have a family in the country or in that area where the court is, or all the family members are living far from the court? Do they have children? Are the children going to school? Are they working? Yeah, all those factors will show ties to the court's area of jurisdiction. Any assets held by the accused and where they are located. Do they have a house that is belonging to them here, or all their properties are outside the country where they come from? Any means that they have to travel in terms of finances. If it's an Uber guy, like these Uber bike drivers, I don't know. I don't really, but I don't think no matter how busy they can get, I don't think they will be making like 30,000 rands a month, So if this guy tells you that I'm from West Africa, right? Hold on for me, please. Sorry about that. No, the means of this person, can they easily afford to travel? Their travel documents that they have, do they have like a passport? Like in the example given that someone can surrender their passport in order for them to assure the state or the court that they will not be able to easily travel to their country or out of the country. The extent, if any, to which the accused could afford to forfeit the bail money. So if it's a hefty amount that is being paid, can this accused just turn a blind eye to paying 200,000 rands bail and just decide to flee and never come back? Can they afford for that money to be forfeited to the state? The ease of extradition in the event of a flight across the borders. So if this person leaves the country, does South Africa have an extradition agreement in place with the country of their origin, so that the court can be, assured that it will be easy for this person to be extradited back from their country? The nature and the gravity of the charge, the strength of the state case, the nature and the gravity of the punishment in the event of the conviction. This one, ladies and gentlemen, if it's raised by the state, you have to address it, because it is likely to be them who will say the accused is facing a very serious offense, and the likelihood is that if the court convicts on this matter, there is not going to be any other type of sentence that the court will give except court custodial sentence, And here we are talking about those offenses that carry minimum sentences. So there you know you have to address the fact that yes, it is a given that there is a minimum sentence that is suggesting the court to sentence direct imprisonment, but at the end of the day, the state still has to prove its case, and you make any submissions concerning the quality of the evidence that they have and the defense that you'll be raising to show that they may not be able to secure the conviction. So the fact that the offense is serious doesn't mean an automatic conviction. The binding effect and enforceability of possible conditions on the bail being placed and the ease with which these conditions can be breached. So you can make a suggestion that, look, if the court is concerned that they would want this person to be reporting regularly with the police to ensure that they are still within the radius of the area where they are supposed to be staying, then you would even go as far as to say the accused is staying 2 or 3 kilometers from the nearest police station. They are even willing to report at that police station every evening, because don't say in the morning, guys, because everybody goes out for work and whatever. Maybe say in the evening by, I don't know, 6 or 7 p.m., they are willing to be going to a report at that police station to just show that they are still within that area. They haven't left. The likelihood of a heavy sentence being imposed in the event of a conviction is also a factor. But please read that case of State versus Hudson to see how, like I've just been saying, that even with a hefty sentence that is likely to be given upon conviction, it shouldn't be the main factor that will influence the court to say, this person knows that if I convict, I'm sentencing them to direct imprisonment, therefore they will run away. It shouldn't be. The strength of the state case was dealt with in the case of State versus Lulani. So you can see how you can address the strength of the state case, because it is a very important factor that will also influence whether the state will be able to prove its case or not. Now, the next factors that the court should consider is whether there's intimidation or influence of witnesses that will take place if this accused is granted bail. Whether the accused is familiar with the identity of the witnesses is going to be the number one issue. And whether the accused knows the type of evidence that the state intends to introduce to prove their case. If the accused doesn't know the witnesses, he has no idea what kind of evidence they have against him, then it cannot be said that the accused will intimidate witnesses or will tamper with the evidence because he doesn't know what they have. Whether the witnesses have already made statements and have agreed that they will come and testify. So a witness, to be said that they are a state witness, it's only when the state has obtained a statement from them which is supporting the state case, right? So if this person, the accused, knows that the person was maybe a witness of the incident, right? But that person has not given any statement to the police. It cannot be said that because the accused knows that that person was there, the accused will influence them. Because the accused, remember, even at this stage, the accused doesn't really know who the witnesses are because he doesn't have access to the statements that are contained in the docket. Whether the investigation of the case have already been completed or not, how would the accused know if they are done and what they are done doing and what they still intend to do? Because when they ask for a remand to do the investigations, they may simply say to the court, they still have investigations that they are still needing to do, and they can only say that there is still maybe witnesses who still need to be interviewed. You don't know whether this is an expert, you don't know whether this is an eyewitness. All you know is that they said they still need to obtain state witness statements. So really that becomes something that cannot be put on the accused to say they haven't done a complete investigation of their case. Therefore, the accused shouldn't be considered for bail. The relationship of the accused to the witnesses, if they know each other, right? The extent of possible influence and intimidation will often be mentioned, that the accused knows the witnesses because maybe they are family members or they live within the same neighborhood, and it is there's a concern on the part of the state that the accused will interfere with their witnesses. So how do you cure that? You can simply say, look, yes, the accused knows them, but the accused, has indicated no interest in, making contact with those witnesses directly or indirectly. And if it's a family, maybe the accused has even opted to move away from that place to stay elsewhere where there will be no contact with those witnesses. How effective will it be possible for the bail conditions prohibiting communication to be effected? So if the court says no contact with state witnesses directly or indirectly, why would the accused be stupid to make contact with those witnesses? Because of course, if it's a condition that has been placed by the court that do not contact the state witnesses because you know each other, don't call them, don't go to them, don't send people to them, and the accused actually does that. Once that report is made to the court that the accused is, the court will now relook the release of bail and consider cancelling the bail of this accused. So whether this accused has access to evidential material which is to be presented. If the evidence that the state has obtained, and let's say it's a case of drugs, that evidence or the drugs will be under the safe custody of the police. So can the accused leave his house and walk into a police station, enter the SAP 13 bits that are booked into that SAP 13? How easy and will it be for the accused to do that? So the case with which, the ease with which that evidence, the evidentiary material could be destroyed, or any other factor that may be concerned, to the court. So you'll say, this in this material, whatever it is that they would present as evidence, is even either unknown to the accused, or if the accused is told that there's drugs, it's under the watchful eye and safe custody of the police. Accused has no access, doesn't even know where exactly is that evidence being kept. So the state then shouldn't worry that the accused will tamper with that evidence. Janus?
Yes, ma'am. Thank you very much, and a good evening to you. I realized that it is.
Can I say something? I think you're gonna tell me it's 7 o'clock, ne?
Indeed, I am, ma'am.
So, Makasani, if that was also your question, I just wanted to finish the slide. That's why I was just going. So, if Makasani has a question, can we deal with it? Can we do 10 minutes today, please?
Of course, ma'am. The comfort break in itself is it's a kindness, and whether it's 10 or 15, we'll accept it either way. Thank you very much.
Okay, then.
Okay, ma'am. My question will come after the break.
Yes, 17, 18. I mean, 7, is it what? Yeah, 18 past 7 in 10 minutes. Thank you.
All rise.
Richard. Hello, 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 hello.
Yes, ma'am, we here.
We
Okay.
here.
All right. Welcome back. So I think we had a question. Was it Makosonke? I think we had a question before we proceed.
Ma'am, it's Mahasani, Sutu.
Oh, Ki Mahasani.
Mahasani, yes.
Dumela Mahasani, you are welcome. Please ask your question or comment.
Thank you, ma'am. My comment, ma'am, is through experience when we're talking about bail. I used to be a cop many months ago in my life.
You used to be a what? Police?
A police, yes.
Oh, okay.
Yes, it's some life experiences. And during that period, we used to deal with these violent crimes, the unit I was in. And talking about bail, how the courts will see it and weigh it against the interest of public and justice and all that. We used to have this guy who used to commit heists. So once he knows that he has been identified by the police, he would ask his lawyer to escort him to the police so that he can be arrested. I remember the first time the court, based on that, that this guy actually brought himself to be arrested. He was given bail, and he committed another one in another province. And he also asked a lawyer to escort him so that he can be arrested after he was identified. And he got the bail. And the third one, it's when we collated all the cases and said, no, but hey, this can't be carrying on and on like that. And we actually put a very strong case to show that this guy, if he's out on bail, he's still gonna commit the same offense again. Even if he can get bail, he will do it again. So I think the bail application went for something like a week where we gave evidence. And eventually the court decided to say, no, but we can't grant you bail this time. And he sat in prison until the end of when he was sentenced. And yeah, so just to add on some certain grounds on which the case will look at bail, and the second thing which I just wanted to add on bail as well, it is I forgot what I wanted to say, but maybe it will come during the discussion. Yes, thank you.
So I think before you go, let us just applaud you for the good work that you did as officers there to ensure that, you know, at least it was your duty to make sure that the courts that deal with those bail applications, maybe the other ones were not aware that this person had been granted bail at other courts. That's why you see, when Richard said there's good cops, there's okay cops, and there's bad, very bad cops, because if they don't do their homework to check the profiles, you know, to follow up on any other incidents of reports against that person, the court will decide the case based on the facts that is before them. So then you may call it luck on the part of the defense lawyers who are busy getting bail for that guy up and in the different courts, but it's actually a miscarriage of justice that, you know, somebody was not doing their proper job to bring it to the courts that are dealing with these bails to know that there's other offenses, and it seems to be a pattern of the same type of offense. So yeah, well done to you. Richard?
Ma'am Elsie, you know, you brought memories back with section 60 of the bail of the Criminal Procedure Act with regards to bail. And I must say this, and if not going to say this, I'll not be able to sleep tonight.
Mm.
1996, 97, I was part of a task team with the late Justice, with the late Dalla Umar, was that time the Minister of Justice, to serve on a task team in drafting Section 60 of the bail regulations and Section 60 of the bail I used to call it the Bail Act, Section 60, because it had to be separate from the criminal procedure, and that was my argument that time when I served on that subcommittee when they drafted the bill. Yeah, and yeah, it just bring memories back when I served on that with people like Willie Hofmeyer and Herman Kronedim and Lulani Nuka them that time. And what we must keep in mind is Section 60 of the Bail, we stop calling it the Bail Act, of the Criminal Procedure Act, of the CPA, was to bring it in line with the Constitution at the time. And there were a lot of amendments to the Constitution in terms of Section 35 and all the Bill of Rights at the time. And what my learned colleagues, and I'm very passionate about criminal law, because I'm in the prosecuting side
but thankfully you are joining our ranks. Yeah.
and I'm very passionate about it, is that with bail, we need as attorneys to adduce all evidence the state puts before the court. Call witnesses for your clients. Call everybody if you feel there is a miscarriage of justice in the bail applications. I just want to say that you brought memories back now for me. Thanks.
I'm glad I did, because I've noticed. That's why when I do this this course, I have noticed, because I'm in an office that had a big group of candidate attorneys, and if you know, because at times you would step into their court and see how they are doing their bail applications. There was a practice of just asking, hey, I have a bail today. Does anyone have a bail affidavit for me? And they had a standard bail form. So I had an issue with that, because I was like, okay, I understand when you are starting out, but I would really like to see how they run these bail applications. And then I came to court and I found they would just run through the bail form, read it by filling in the missing words like name, age, what, you know. And I was like, but there are serious allegations that are coming from the side of the state, which you are not able to address in that affidavit. How do you deal with that? You know, and if you have issues, do you know that you can actually, because sometimes the state doesn't call the investigating officer to testify, they would just also come with an affidavit or a statement made by the investigating officer. And sometimes those statements are very sketchy about the details of the case. If you find that it doesn't shed enough light, because the court needs to make an informed decision before it can decide whether or not to grant bail. So if the information is not enough, you can suggest to the court that at this point it's unclear what kind of case that the state has, and whether they will be actually in position to can have a case that they would be likely to secure a conviction on. And you can say what is, you know, the loopholes that are left open. We don't know this, we don't know that. At this point, you know, Your Worship, I'm requesting that the court consider actually having the investigating officer come before the court to testify, so that all these unanswered questions can be, you know, addressed. It's not only the state who can call for the investigating officer. if you know that, that's because they will give you that affidavit of the investigating office, and you will see there's just too little information to can convince the court about what is the state of this case and the issues. Maybe there's an allegation that is very serious made on that statement. Now, you can't cross-examine that statement, but if that officer can actually come in court, you can actually put questions to properly deal with those issues that are of concern to you. So yes, bail it's a very, very interesting topic, and we really actually lawyers need to make it. I mean, despite what I put on these slides, guys, there is a lot more that you can say or do during a bail application, but I'm just trying to show you, because I've seen when people are addressing the court, they will just simply say the accused is not a flight risk, the accused has no knowledge of the witnesses, the accused will not tamper with evidence, and therefore the court can consider granting bail. No, man, you are just running over the top, on the top. You need to go in. So that is why I decided to do these bullet points to show you how you go in on each and every factor. Thank you. So yeah, we're gonna finish these slides, I think, tonight, and then we'll stop there. So the next one is whether when the court is to determine whether the criminal justice system is going to be undermined or not, and whether the accused deliberately falsified information at the time of his arrest or during the bail proceedings. So please note that the bail proceedings are part of the court record, meaning whatever that is said by the accused during a bail application can be used against them in the trial. And whether the accused is in custody on another charge, like the example that Richard gave, or is on parole. Some people are saying Jub is still on parole. I don't know. Any previous failure to comply with bail conditions, or any indication that the accused will not comply this time. So those are the factors that you will highlight to the court. Factors considered in determining the likelihood of release of this accused causing public disturbance or the undermining of the public peace. So this is where we have a public outroar, the public outrage, the public is vocal. They are, they are there. They are, making it well known of their disapproval for the court granting bail. So if this court needs to determine whether that release will make the public to maybe turn violent, and not respect the decision of the court and cause, public disturbance, then you would say to that, whether the nature or the circumstances of this offense are likely to induce a sense of shock to the community in which it was committed. So if it's now a factor that the court needs to look about whether the court, the community would be outraged, ne? You have to address the issue of shock, because if this public or the members of that community have expressed their disapproval on the bail being granted, because maybe you can check also how did they feel about the offense as it just happened. Maybe there was a great shock that was expressed by the members of that community. Is that something that you need to address? You cannot ignore it if there is shock that has spread throughout that community. So you cannot just say the court doesn't have to bow down to the needs of the community. The court has to be impartial in its decisions. Remember, those people, if they are in this sense of shock, they can act out in any way that can end up even being violent towards the accused. So whether this shock or outrage might lead to a public disorder if this accused were to be released, and whether the safety of the accused might also be jeopardized by his release, and whether this release would then undermine or jeopardize the public's confidence in the criminal justice system. So this matter of State versus Mohammed and State versus Bennett dealt with the possible public disturbance that was to ensue after the court considered granting bail to an accused. But the best and most likely thing that you can suggest in that kind of a situation, because maybe if your client is adamant that they want bail, you can maybe consider advising the accused that, look, we either lie low a bit, we let, you know, tempers to rest, and or if you do proceed with this bail application under those heated circumstances, then the accused cannot go back and stay in that same area, because it's guaranteed that they're gonna be, you know, yeah, attacked if they go back there. So you can opt to suggest an alternative address where they can stay away from that members of the community having access to him or her. Okay. I did talk about the differences between Schedule 6 and Schedule 5, and what you need to show to the court to convince the court that it can go ahead and grant you bail. And please note that during a bail application, the accused, or you as the lawyer, if you are legally representing this accused, you are compelled in terms of Section 60(11) capital B to inform the court of any previous convictions and pending cases, or whether this accused has been released on bail in another court or not. So you know, with new lawyers, they always have an issue about lawyers sometimes, you know, lying on behalf of the clients and whatever. I always say there is no lawyer who lies on behalf of the client. Lawyers act on instructions. If there's anyone who's lying, it's the client. So the lawyer is also being lied to by their client if the information that they are passing on to the court is actually a lie. So, and when it comes to seeking the truth as a lawyer, this is the only time that you as a lawyer, you have to plead with your client that I beg of you, the one time I need you to tell me the truth, and I will never ask you to tell me the truth again, is now. Do you have any pending cases or any previous convictions against you? Because if that information later turns out that they lied, or they lied basically, they have previous convictions and it doesn't come from you, it's been produced by the state, it has serious consequences, of course, for the accused, because it already shows the court that this person is a liar And remember, this person still has to be undergoing a trial where you're still hoping that the court will find them innocent. And also, they can be charged for lying to the court based on them not disclosing their previous convictions and pending cases before the court during a bail application. The situation is different when we're now dealing with sentencing. This is the responsibility of the accused to disclose this information. But if you are dealing with sentencing, it is now the responsibility of the state to prove that the accused has previous convictions or pending cases. So this is your duty now. You have to disclose. There's consequences if he doesn't, if they don't disclose. So the record of these bail proceedings, I've said that they are part of the whole entire record. And it is also your duty as the lawyer to warn the accused not to say anything here in the bail that they will later change in the trial, because that can be used against them. So consistency, consistency, consistency. Often, if the information relayed in the bail application, where it tends to be different to what is being said in the trial, the prosecutors, they actually get the records for the bail, and they do confront the accused during the trial to show that the accused is someone who is a liar. They confront the accused during the trial that there is evidence on record during your bail application, you said this, but now here in the trial, you lying to this court by saying this. So you changing and chopping your story as you go along, you are adapting your story, you are lying. This court cannot rely on anything that you say because you are not someone who is truthful. So you have to advise them to stick to their story from the outset to the finish. Yes, Nontobeko.
I wanted to just gain clarity on, I understand that it is the state that needs to prove that the accused is guilty of the crime or of the offense that they're charged with. But is it advisable for a defense attorney to then ask their client, while consulting, of whether they are guilty or not guilty? Like, how is that conversation had? And of course, I understand as well that just because should they then tell me that they are guilty, I don't necessarily have a duty to disclose that to the court. But I just want to understand, like, how is it handled between the client and the accused and their conversations?
Your conversation with your client is supposed to be confidential, and it should happen in a setup that would make the client to feel free to, it can even, confide in you about the significant details of the case, to the extent that if it comes to that they will tell you that. But remember, the rules of ethics, they bind you as an officer of the court. You are not supposed to mislead the court. So if you are in consultation with your client and really it's just the two of you and there's no one who's listening in, and they make some admissions that are to the effect that they have actually committed the offense, right? You need to establish from them whether now are they comfortable to now proceed to give you instruction to plead guilty, because they are admitting the offense and you check the elements of the offense as you know the law, that indeed they are admitting all the the elements. And if they, and then you advise them that yes, from your own admission, you are admitting this, you are admitting this, and the offense that you are charged with is this, is this, is this. So then can I take it that you are pleading guilty to the offense because of the admissions that you are making to me, that you are the one who committed the offense? And if they say, no, I don't want to plead guilty, right? Okay. So why don't you want to plead guilty? Because you are admitting to having committed the offense by your own story, that the version that you are giving me. They have to tell you. So you have to establish whether maybe they don't understand fully, maybe how the law operates in terms of how they, maybe for instance, they say, yeah, this is an assault case. Yes, I did beat him up, but in actual fact, we started out in just an argument, and then eventually it turned into a fight. So I admit that I beat him and I did assault. I can't deny that the injuries that maybe they sustained is because of me beating them. So now you have to determine whether they were justified in terms of their actions, whether the law allowed them to do what they did. So you'll have to advise. And if they were not justified, you have to tell them that no, maybe you acted in defense, in self-defense, when you say they are the ones who maybe beat you first, and the start of the fight was just a fist fight, but because you say they were overpowering you, at some point you remembered that you actually have an okapi knife in your pocket. Then as you were busy punching each other, you decided that you can't take the punches anymore. You decided to use what would finally stop this fight, and pulled out your knife and you stabbed this guy. So it becomes now self-defense, yes, but now did this person not exceed the boundaries of self-defense? So you have to fully advise your client in that regard, you see. But you cannot, if you find that they were not justified in any way, be in cahoots with the client that they do not disclose to the court that they committed the offense. If they tell you that they're the ones who did it and they don't have any reasonable defense that they can raise, or if they don't have any reasonable defense that they can raise, you advise them that, look, you are guilty as charged. And my advice to you is, we plead guilty because you are saying it, that you did this, but maybe what I can do for you, I can look for maybe you pleading to a lesser charge, and maybe do some plea bargaining, try and get you a lesser sentence by engaging with the prosecutor, and also even the magistrate, that we can try to get you a lighter sentence than what you would have got if you pleaded to the main charge. But you cannot have fully clear instructions of a guilty, and then you decide to come to court and you proceed to give a version of not guilty if your instructions are that the client is guilty, because you are not supposed to mislead the court. That's the rules of ethics. That's not El Cine. We are all bound by the rules of ethics. Richard?
Ma'am Elsie, tomorrow night, I promise I'll keep quiet.
No, you must talk. It's for the last day, Pearl. We need the last push.
Yeah, there is a couple of things I want to address. Sorry for the barking dog.
problem.
is I just want to go maybe 4 or 5 steps back. When the court informed the accused, you're not supposed to intervene or make contact with the witnesses. You can, because a lot of cases are these days on TV, you know, when it's high profile cases. And I'm speaking from a prosecutorial point of view, is that the court can ask everybody to leave and put the cameras off and everything, or either to give the list, only the name list, to the defense, to say these are the names of the witnesses that your client should not make contact with. That's yes. So you can call the court in camera. I don't mean on like we have these days on TV, and I'm against it.
Even today, they were looking for Jub up and down the court.
Yeah.
Like Jub is gone.
And
Anyway.
And also the other thing, Ma'am Elsie, is that we must keep in mind these, when bail is paid, checks has been made away with in courts.
Sorry about
It's
that.
only cash. It's only cash when you pay bail money. And I don't want to go into the details of the case, but my last comment was is and maybe we'll deal with it, is the access to information for your client's bail hearing. And I'm speaking about the police docket and things like that. And I'm not going to go into detail about it. And my learned colleagues can maybe go read Green. It's a 2006 case. And then there is Joseph, which was a 2001 matter before the Constitutional Court, where the discretion is with the prosecutor to disclose certain information, but the justice goes on there in that case, is it reasonable and all of that and things like that. And that's very important when I touched on the adducing the evidence. And in that, in the Joseph case, the court referred to section 60, subsection 14, which says, because section 60, subsection 14 says, it cannot be used to deprive a bail applicant of the reasonable opportunity to adduce evidence or make appropriate submission in support of his or her application. So the justice lay out there in the Constitutional Court. Is it fair? Is it not? I'm just going to leave it there for my learned friends. Thanks.
Maybe write in also the full citation there in the comments, because you went through it quickly. We'll appreciate that, Richard. Thank you so much. Zulu fellow.
Okay.
As a defense lawyer, let's say we spoke about your client admitting to his guilt in your consultation, right? Then he tells you everything, and then obviously after you receive disclosure, you can see that it's not looking good, but he still insists on going to trial and goes against your advice as a legal practitioner. So now I've experienced that with legal aid. Most of the time they are so frustrated because their clients would insist on going to trial, and I'm like, don't you have an obligation to also withdraw if it's against you are advising him, but he's proceeding to say that he's not guilty, but everything, or rather disclosure, shows otherwise. You as a defense attorney, can't you withdraw on that basis to say that the instructions given is not according to your legal advice? Can you now withdraw on basis as an attorney? Because now you're going to go to court, and not only is his version going to be improbable, but ridiculous, and you're going to make a fool of yourself because his instructions is saying not guilty, but you can see that he is Do you understand? So what do you now do as a defense attorney?
No, Tolu, you are saying you as the state, you are of the view that you have a strong case,
Yes.
right? And you are expecting the attorney to advise the client to plead guilty. But the lawyer comes back after consulting, you gave contents, they've thoroughly consulted, and they say the accused is pleading not guilty, they want to go through trial. And you have a problem with that. You feel that that lawyer must withdraw.
No. I'm saying, what do you do as a defense attorney in that instance after advising him to say, but it's not looking good, but he's still insistent. He's saying he's guilty to you, but he says he doesn't want to plead guilty. He wants to go to trial.
Do they
And
have
you
a
now
version that? Do they have a version that they're giving you to go to trial with? If they say
yes, then they give you, and it's improbable.
Then
And
you
that-
take instructions. Then you advise on the version as it's given to you. As I said to you, remember, when you consult with the client, you make the statement to be written down so that you have proof that is what they told you. And then you also are expected to give advice based on that instruction to say, look, these are the good points about what you're saying. These are the bad points. This is the state case that you're facing. This is their bad points. This is their good points. And me as your attorney, this is my advice to you. But the fact that you are insisting to proceed with the trial, you have been fully advised. Sign here, then you proceed. Because remember, if that attorney now, because they believe that from their own personal reasons that this client is supposed to plead guilty, it's not their case. It's the accused case. They are there to legally represent and advise. And if the client refuses to take instruction, then, I mean, not really take, advice. It's their choice how they will. I mean, they are giving them a version to proceed to trial, and they can also advise them based on that version to say, look, the version you are giving to me, it's gonna be challenged on these aspects and that aspect. But in any event, you are adamant you want to go to trial. So here, sign, we proceed to trial, and I'll do my best to deal with the evidence as it comes. But you cannot force an accused to plead guilty.
Okay.
Yeah.
All right. Thank you.
All right. Sambo, I think you are next. Okay, Sambo is gone. Let's run through the slides.
I'm here.
So
I'm here, my everything. I'm here.
Oh, I thought.
Yes, how are you? Thank you. No, I think it's this load shedding and technical issues here.
I may be off, but I'll come back if I'm disconnected.
No problem. Okay. One is just a comment, just a silly comment, and then the other one is just a question. I've just like as my previous colleagues have alluded here, I've seen a rising trend in the accused, especially like you find that, like, for example, in the case of Jub, fortunately I was in the Randburg court today, and I could speak with my other learned friends in court, and you realize that most people, or the accused, when there's a warrant of arrest that is issued against them, they would therefore want to find an easier way to try and persuade the courts or the presiding officers to therefore have it easy for them to be granted bail by just taking themselves to the nearest SEPS stations and stuff like that. That's just like the comment, because I've seen the rise of that even in other local police stations. As you go, you'll just be sitting there going to certify, to commission something, and you find someone saying that, okay, no, I've hit my wife, or I've done something. So I think I don't know whether it is the advice that they get from their legal teams to say that, look, another thing that could work to your favor is just you presenting yourself to the law enforcement, and that during bail could work into your favor. The second thing is just a question based on the public outrage. I think it's on slide 30. Yeah, it's on slide 36. I want to just for ease of reference and just for my understanding, this is not binding, it's just for me to understand this course as we move on the topic of bail. I'd rather consider that there's maybe two ways of bail. There's a positive denial of bail, and which doesn't favor the person, the accused, and then there's the negative one, which is the complete denial of bail, which the positive one, I could rather say it's being denied bail for your own safety. So I had the privilege of visiting correctional service facilities the past 2 years, doing research on the rights of incarcerated people. And in those facilities, one of them was Pollsmoor Prison, and sitting in the group with inmates, they would say, "Look, I'm not here serving sentence. In fact, I'm here because maybe the community in Menenberg or somewhere in Hanover Park is looking for my head, so I am protected here." So the question to this was to find out whether the Department of Justice and the Correctional Services, in the event that you are not granted bail for the sake of protecting you against the public outrage and you not being accepted back into the community, and this could be that no, I mean, you are well known, your case is well known all over the country, like it's been on the tabloids, it's been everywhere, and now the presiding officer just decides that, look, we see all the facts, we are convinced that look, you qualify for the other stuff, but the public would not accept you back. They would rather do harm to you or something like that, and that will defeat the ends of justice. Do we therefore, in your knowledge or anyone else in the group, do you have maybe information as to whether that is where we can therefore look at the special care in the correctional services where one is under bail, but they are not incarcerated or they are not detained in the same facilities, just to put the inverted commas there, as the other inmates who are serving or awaiting trial? Are there facilities or houses that are outside of the correctional facilities which are built to keep such people who are would be endangered once they become part or they are absorbed back to the communities? Yeah, so that's my question.
Okay, we are lucky to have members of the former SAPS members who are within the class here. But from my knowledge, the state really doesn't have a specific facility to cater for accused who are in danger of the community, like you say, to be kept in a particular institution for safety reasons. I only know that they have like what is called a witness protection cover for their state witnesses, where they used to have houses where they could keep witnesses to stay there without them being traced to where they are staying. But for this,
I just don't know. I don't have sound. Does anybody else have sound?
I don't have sound either. I don't have sound either.
I think man might be load
I
shedding.
now have sound.
And also my screen is blank.
She said load shedding.
Yeah, she did talk about load shedding. Maybe she's reconnecting again. Let's just give her a few minutes.
The court will adjourn for 5 minutes.
As the court pleases.
Richard. I'm back. Can you hear me?
Yes, ma'am.
Yes.
Okay, so you know,
Yes.
I thought we would finish before the load shedding. I
Yes.
didn't change the other device, so because I thought we'll be done by 8 o'clock. So this other one takes a bit to kick in, but yeah, we are fully connected now. Yes, sorry. I think it was director Bala or Bila.
Sambo,
So,
it was Sambo.
Sambo, sorry, but I know you are
Yes.
director. Yes. Sorry. Please finish what you were saying.
Okay, no, I think I've just asked, I've asked those two questions, and yeah, you were just telling me that you know of facilities that then existed in the past where witnesses would be, you know, accommodated in, but you don't know of any which could cater for the people that are out on bail and those that could be endangered once they become absorbed back to their communities.
Yes, I was saying that. Thanks for that. I was saying I'm only available. I'm only aware of that kind of protection and places that would be made available for state witnesses, not for accused. But because we have, you know, former SAPS members and law enforcement officers here, they may know something that I don't know, if they can shed light. So what I know with my colleagues with these kind of cases, I remember there's one who said there's a gang in the prison who are waiting to kill him. If he's not released, then he's also in danger from the prison community. You see, so the danger can be in the prison or outside of the prison. So I don't
Yeah,
know which side.
I echo with that sentiment, ma'am, because I think following the Thabo Bester case, it was one of the things that was raised back in the day in 2011, I think, when it started, when I think before his escape, it was said that the reason why he was moved from the cell where he was to cell 35, which now becomes the one of the biggest exhibit in this case, it is due to the fact that there were threats and stuff like that. So if there's an internal process, I believe, within the correctional facilities where if there's threats to certain inmates, because they are categorized and classified from, you know, the degree of their sentences and stuff like that. So I was just like wondering if it does happen to those that are not yet sentenced and stuff like that, whether they can be kept in safer facilities, maybe the medical wing of the correctional service facility, or they are kept in you know, the, I don't know whether it's like, maybe the former SEPS members can tell me, or those that have worked for the Department of Justice, maybe there's the hotel part of the prison, if there's ever something like that, just for
There's
them
no
to be
hotel in
protected.
prison. You're watching too much social media. You. Or you saw those pictures of Thabo Bester wearing Louis Vuitton.
Yes,
You don't
yes,
even know it's fake. Yeah, I see Richard, maybe he wants to help us here.
You know, they call the prison in Joburg Sun City.
Yes, where the sun don't shine. That's what they
Yeah.
say.
Ma'am, to my learned colleague on the other side, you've got two options. The one is to make contact with the inspectorate judge. I think it was last time when I saw him, Justice Judge Nathan Erasmus. He used to sit on the bench on the High Court. It's Nathan Erasmus, or I think he's been replaced now by Justice Cameron of the Constitutional Court, the inspectorate judge that goes around to the prisons. But you must be in custody in prison.
That's what I know. That's what I wanted to say.
Yes.
Because I've
Yes.
actually attended meetings with them, and it's
Yes.
all about the in custody. So
You
I think
must be
that-
in custody.
Yeah, yeah.
If you're out of the custody, I don't know where my learned colleague is. I heard the name, use the word Hanover Park, or so I think it's most probably Paulsmoor. Is to maybe approach a law clinic in your area that deals with. If you're in Cape Town, you can approach the UCT law clinic or the UWC law clinic. Law clinics normally assist with it because they do have a division in law clinics. And Ma'am Elsie would also know the law clinics is all over South Africa. So if he's out of custody, is to approach the law clinic. If there's a threat on his life with gangsterism and things like that, is to approach the Provincial Commissioner of Police or the investigating officer of the unit where the matter is being investigated. Thanks.
But I
Thank you
think
so
what-
much, Richard. Thank you so much.
what-
I'm in Joburg though. But yeah, thank you
Yes.
so much for that.
Yeah, no, that's helpful, Richard. But I just wanted, I thought maybe you would say something about, I know that they used to have houses where they used to keep, used to call them safe house. That's where the state witnesses would stay. So I think I was actually hoping that you would say that, can they also accommodate an accused in a safe house? And in my mind now, when I wanted to ask you that, Richard, I'm just quickly thinking that maybe they wouldn't be able to do that. Maybe they would rather opt to advise this accused is not in custody, that they stay in a safe house. You know, there's these ones that are like a place of shelter for maybe where the abused women and children would stay. Like you have, there's quite a number of them. I could think a place like that could be approached to house the accused and not disclose, because normally, for instance, if it's a complainant who says, my husband is beating me up in the house, and I'm afraid that, once he knows that I've opened a case for him, he may actually kill me. So they would then take that complainant to that shelter kind of a place. So
Yeah.
I'm thinking, that's what I was thinking.
If you look at a person who was arrested or others in custody or in non-custodial, that witness must be able to, or the person that my learned friend is referring to, is you can then maybe apply to the DPP's office to become a Section 204 witness. But with Section 204 witnesses, you need to give incriminating evidence.
And we are coming
against
to
yourself.
that, I think, tomorrow. Yeah, we'll talk
Yeah,
about that. Yeah.
and maybe we can look at that. But what I don't want to keep the class up, but what your learned colleague can do is he can email me, he can get my email address maybe on the site here. And then I can assist him on that level, or you can email me. Just on Zuki, Zuki help you here. I will most probably be able to assist my learned colleague there. Thanks.
Thank you so much, Richard.
Thank you, Richard. Thank you so much.
Okay, so yeah, we were here, and bail conditions is the last, okay, almost the last. thing about the bail. Bail, once it is granted, or if the court is considering granting it, you can also use the fact that to motivate the court to be granting bail, that the court can impose bail conditions, and those bail conditions can be granted subject to conditions. And the conditions, of course, have to be, they must not be contra bonos mores, meaning something that can be said to be out of what is accepted by the norm, must not be vague and ambiguous. They must not be ultra vires mores. They should be practically feasible. So it must be something that it is within the ability of the accused to comply with that condition. And you can also have a situation where, despite the conditions that the court is suggesting, further conditions may be subsequently, on application by the prosecutor, be added. So with this topic of bail conditions, I only have one more thing to say. I guess it's out of maybe desperation or wanting to flaunt as an attorney, to show off that you are fighting and you are almost there, you are about to get your bail. When it comes to this issue of bail, I see that it's not being addressed properly by the lawyers, because they would be making submissions that they've been able to show evidence that the accused is an ideal candidate to be considered for release on bail, and further to that, a request that now the court is requested to release the accused on bail, and add that the court can be also requested to impose bail conditions on the accused, which is willing to abide by. And the words that they choose is what I have a problem with when they speak. They say the court can impose any other condition that they deem fit for the accused to abide with, to show their eagerness that they want to cooperate. You see, my problem with those choice of words, you are leaving it up to the court to decide the conditions that it wants to impose. And now, remember, the accused has to abide. Once the order is made that these are the conditions, the accused must comply. Failure to comply with these conditions has dire consequences for the accused, because the bail can be revoked, because the accused can be seen to be unwilling to abide with the bail condition and not respecting the order of the court. So when you ask for these bail conditions, which is good, don't say the court can impose any conditions. Say the accused is, willing to subject themselves to the conditions being placed on him by the court to abide with. And we are suggesting, for instance, that the accused will be able to report to a nearest police station to where he resides on, every second day in the evenings. Don't make it something that's gonna be too like unbearable for the accused. Because now sometimes they would even say the accused can report 2 times in a day. Guys, the accused still has to wake up, go to work, face traffic, there's load shedding, and it can't be getting to work late every day. You understand? Now, what happens? The accused comes back to you and tells you, I'm not able to make work on time. My job is on the line. Now you have to come back to court to do what? To ask the court to relax the bail conditions. And in most instances, that is highly irritating to the court, because they now start to somehow view the accused as if he wants to be difficult, he doesn't want to cooperate. because the bail conditions were set. And what did you say at the end of the matter? As the court pleases, Your Worship, we are indebted to this court. In fact, this is the end of my role. May I be excused? All those beautiful words that lawyers say. And then you walk out with your shoulders up. Now you are running to the clerk's office to pay the bail. But your client is not going to be able to abide by reporting to the station 2 times in a day, every single day. You understand? So you need to take instructions and find out, will it be possible for you on every day? If it's not every day, at least every second day, or at least maybe on every 3rd day of the week. You can even say if it's Monday, Wednesday, maybe Saturday, that they will be reporting to the station at a specific time. Because if they get there, the investigating officer is not there, somebody who's supposed to confirm that they actually did show themselves at the police station is not there, then it becomes as if he's not abiding by the conditions. So just be careful with that request for the bail conditions and make sure that you've taken proper instructions on that issue. Of course, when you come back and you say the accused is not able to abide with the set conditions, the court will want to know what is making them not to be able to comply. Of course, they will listen and hear you out, and maybe they may relax the conditions, but sometimes they may not. You see, now it means you have to go to the High Court to now go and fight for the relaxing of those bail conditions. It's money also out of your client's pocket, which is something you could have done right from the outset by asking for conditions that are within the, what your client will be able to do. So it's good when you ask for the bail conditions, because it shows eagerness for this, accused to, to be playing, along with whatever conditions that the court will place, and avail themselves whenever they are called upon to show themselves. But yeah, please just be careful with that. So the next thing is this one. I don't know if any of you, maybe you might have heard of it. There's a section in the Criminal Procedure Act, 63 capital A. It grants certain powers to the head of prison in certain circumstances to release on warning instead of on bail, or to amend the bail conditions of an inmate. This is someone who's already been a part of correctional services. So where the head of the prison is satisfied that the prison population is reaching such proportions that it now constitutes a material and imminent threat to human dignity, physical health, or the safety of the accused and other inmates, then the court will identify such persons and then apply the section to those who are charged with very less serious offenses referred to in Schedule 7, to also apply this for minor offenses, like really minor offenses, and also to assist the indigent accused, those who have bail set by the court, but it may be maybe something like 1,500 or 1,000 rand, or even 500 rand bail that has been fixed, but this person continues to sit in jail because there is absolutely no one who can raise the bail money for them. So they need to identify these people and then release them on warning. You see, question is this happening? Because we have a situation in our country where most of these correctional service centers are actually overcrowded, especially the awaiting trial sections. Like I remember when I last visited the Johannesburg prison, the Sun City, they indicated that the capacity was supposed to be around 4,000 for the awaiting trial, but they were running beyond 6,000 with awaiting trial inmates that were there. So This shows that then are the head of prisons really identifying these people? Are they really doing what this section is saying? I don't think so. So there's also section 49G of the Correctional Services Act. This one deals with the accused who are awaiting trial in custody for 2 years. They don't have bail, 2 years or more, where their bail has been refused. So they've actually brought a bail application in other instances, and their bail was denied, right? So after that bail was denied, they've continued to be incarcerated beyond 2 years. This section requires that these inmates should be brought before the court. Through an inquiry, the court should determine whether they should continue to still be incarcerated. Some of these matters, you may find that the evidence the trial has actually resumed. Some, the trial hasn't even resumed. So if the evidence, the trial has already been started, and you can, when you're dealing with this inquiry, go into the evidence that has been, make arguments based on the evidence that has been presented to say that the evidence that is being presented before this court, it's at this point showing that the state is to secure a conviction, or the state will have difficulties to secure a conviction. And for those reasons, there's still maybe this one witness who's still coming to testify. From their state witness statement, it doesn't show that they will change the shape of the case that is already before the court. Therefore, the state will still struggle to secure a conviction there, and you ask that the accused be released based on that section 49G. Last thing on bails. So you can apply for bail based on new facts. So this happens whereby you are, say, in a district court, you apply for bail and your bail is heard. Unfortunately, the outcome is bail is refused. Maybe through another attorney, and then you come on board and you feel that you're going to do a better job than the previous one. So you take your instructions and you feel that there's new information now that you have in your hands that you would want to bring before that court, the same court that refused the bail. Then you bring a bail based on new facts to now show that there's something that was missed in that initial bail application. Please, the information has to be new. I think many lawyers, I don't know, maybe because they're trying to justify their fees or what, I don't know, they just automatically jump to this thing of applying for bail on new facts. And when the courts are listening to the evidence, they will be like, but all that you are saying to me is already on record. This was all placed before me in the bail, in the initial bail application. There is nothing actually that is new that I'm hearing, and it becomes very irritating. So please don't do that. Make sure if you do follow this route of bail based on new facts, it must really be new. So what can be something that qualifies as a new fact? For example, when that bail was done, it seemed like everything was going on as the state case was set before the court. Witnesses would come and testify, fine. Watertight case. Now, when you come on board, you are informed that maybe their key witness has actually had a change of heart, and they saying that, look, I don't actually, want to proceed with this matter, I've, realized that maybe I have made a mistake because I was angry when this thing happened, and I pointed the very first person, and I'm not very 100% sure that actually the accused is the person. That is a new information that you can now bring before this court to show that the state now, the case, the witness they were most relying on is not going to be able to secure them the conviction. You see, that's a new fact. So you can also opt to now approach the High Court and do an appeal for bail. If you do an appeal for bail, there is no need to bring a leave to appeal like when you are convicted in a trial. So you just prepare your papers, you issue, and you proceed to the High Court to go and get your appeal heard for the refusal of the bail in the lower court, right? So you can appeal the High Court either for a refusal of bail, or if you are unhappy with the amount that has been fixed, if you are of the view that it's excessive, then you can approach the court and say the amount is too much. And you can also approach the same court that fixed that bail, the lower court that fixed the bail, to try and get them to do a reduction of bail. But most of the time, those reduction of bail, from what I've seen, it's rare that they succeed. So in that case, then you go to the High Court to appeal on the amount that has been fixed, or on the conditions that the court is refusing to change, the conditions of bail. So, ladies and gentlemen, to distinguish between an appeal for bail or bail on new facts, I tried my best to explain it, but further reading you can do by checking this case of State versus Peterson, and hope it sheds more light on that. So we are beyond our time, which I didn't think would happen, but I hope we don't have any questions. If we do, we can reserve them for tomorrow night. I received the love, I received the claps, and today there's no songs. So I guess we'll sing ourselves lullabies and see each other tomorrow. Bye-bye.
All rise.
Bye.
Good night.
Bye.
Bye, everyone.
There is a
Thank
standing
you.
ovation for Richard,
Bye.
though. Cheers, everybody.